honored guests, distinguished visitors, alumni, faculty, members of the Georgia Law Review and the Moot Court. I am genuinely honored to be in Athens and to celebrate Law Day with you. I was not that familiar with all of the wonderful record of University of Georgia Law School and its moot court activities, though I was somewhat familiar with it. But today, following up on past triumphs, I was, however, very familiar with the Georgia Law Review, and even before Ben's days with me, I have thought the world of this Law Review, and that symposium on jurisprudence I considered to be such a wonderful piece of legal work that I really think it is a legal collector's item, and if you want to make an investment for the future, as I do, I have 3 copies of that for my use not only at the court and in my offices, but at home. I think it's just wonderful. But how beautiful it is to be in Georgia where it is spring. You know, in Vermont, we have only 2 seasons, winter and the 4th of July. I am delighted, too, to be accompanied, I should put it the other way, to be accompanying my law clerk, Benna Solomon, who is a recent graduate of this great law school and who, as some of you know, is moving on next year, graduating from me to clerk for Mr. Justice White on the United States Supreme Court. And I hope she will bring that court the luster that she has brought to our court. You know, there's a great deal of speculation how much various judges rely upon their law clerks. I rely on Bennett completely, of course. Not so much perhaps as one judge I know was always busy making speeches and writing law review articles as well as doing his regular opinions, and would have his law clerks do all of the drafting. He'd often do this on short notice and give them really impossible tasks. You know, I want an article dealing with the economic impact of antitrust regulation on the commodities market structure by next Friday, or the like. Legend has it that his poor, overworked law clerks finally got fed up when he gave them a truly impossible assignment. One evening, tomorrow night, he said, I'm addressing the American Law Institute, says, and I want to present a revolutionary 12-point proposal to modify the entire appellate court structure in the United States. The clerks fixed him up pretty good because they knew that he would never read his speeches until he got up to deliver them. And so they spent the first 20 pages outlining the complete history of the appellate courts in the United States, what they did, and just how things were. And they got to page 21, and they wrote for him, and now I will give you my 12-point proposal of how to completely modify the appellate court structure in the United States. And he turned over the page of his speech, and it says, now you SOB, you're on your own. Now that I am on my own, I do want to tell you that I had to think out just what I was going to talk about in Athens today. My law clerks, Ben and Ken, suggested a day in the life of a federal judge. But I knew that would bore you, because how can you make exciting a description of reading a 167-page government brief dealing with a drug conspiracy that you've gotten on a Monday with the case to be heard Wednesday, and the case has 12 appellants, and there's a 4,000-page transcript. Judge Kravitz, you're going to love it. You probably wouldn't be impressed if I told you that in this particular case, by the time we got sitting on it, I really still didn't know all of the players in the case, and the law clerks are making charts and everything just to inform me what it is. So I dropped that subject. I thought I might discuss with you, as a second alternative, the recent libel case last week, you know, that's been widely in the newspapers, Herbert and Lando, the CBS case, and that was a case where the Supreme Court reversed 6-3, a decision that Chief Judge Kaufman and I had written up in the Second Circuit, and where we thought that a reporter's mental or editorial processes should be protected. But you know, I thought that to discuss that case, and particularly footnote 15 in the majority opinion, might be in bad taste. You know the taste, sour grapes. I had one more possibility that occurred to me, and that was the new field of law called Marvinization or palimony. But then I realized that the field of law was developing entirely too fast for me to follow. Once I read that Michelle's lawyer has already requested that the state of California give him $500,000 in attorney's fees for getting her $104,000 of rehabilitation. So I settled on a subject that I thought might interest all these bright young people who are here about to embark on their legal careers. As students, those of you who have worked on the law review doing research and writing, not unlike the brief writing and all that we read and see all the time, others of you have participated in these moot court competitions, doing not only brief writing but also oral argument, as of course the attorneys at the appellate level do. So I chose my topic to give you the other perspective tonight, my side of the court system, and that's Dr. Oakes's prescription for becoming a federal judge. No, it's a serious subject. I am fortunate enough, one of the few people that you perhaps will ever meet in life, fortunate enough to have achieved my life ambition, and that was to become not only a federal judge, but to become a United States Court of Appeals judge on the Second Circuit. I started on that. I thought about it. It became an ambition when I served as a law clerk to one of the loveliest men, one of the kindest men, and one of the brightest judges that it's ever been my hope and pleasure and privilege to meet. He was just like a father to me, Judge Harry Chase of Brattleboro, Vermont. And I thought that the life that he led was just totally ideal, not just the place, the fact that we spent 3 weeks in Vermont and then would spend a week in New York City getting a little bit of the best of both worlds, 3 weeks writing opinions and doing the research and all, and 1 week of that hectic pressure and crash and complexity in New York. That seemed to me just ideal, and to do it the way Judge Chase approached the whole job with this generousness of spirit and this kindliness to the lawyers and this nevertheless inquisitive and skeptical and driving method of reaching at the underlying reasons behind each decision, not just the cold precedents that were presented on paper, seemed to me just the best of all possible worlds. And indeed, the actual work in this job has exceeded by far my fondest expectations. Our job now, if anything, is more complicated, somewhat less inviting in the sense of additional pressures of time, but it's a little more varied even than it was on the at the time when I was clerking on what was then known as the Learned Hand Court. Because we now do have, it seems to me, a lot more issues of constitutional law, and some of them fairly important. We even had a question recently whether and he isn't here tonight, but I understand he is on his way. We wanted to be sure that he would be here. We even had a question a few weeks ago whether the Attorney General of the United States should be held in contempt as he had been by a district judge. And fortunately, we were able to reverse that decision so that he could be here tomorrow. Now, my prescription for being a federal judge works no matter whether you practice in a big firm or a small, for a corporation or even alone. It matters not whether you have family or social connections, whether you have financial backing or are in debt, as I was when you finished your law school education. It doesn't even matter whether you're from the state that you practice in. I was born in Illinois and practiced in Vermont, although I suspect it wouldn't hurt you any if you did practice in your state of birth. Judges Morgan and Kravich and Kelly and Bowles or Sidney Smith, Judge Sidney Smith, I still call him that. He's an old college classmate of mine and a darn good friend from old days. They might have different formulae or different prescriptions, but mine worked for me, and I think it will work for others. At least I want to share it with you. My prescription has 5 parts, and I will discuss the first 3 in a little depth. Number 1, polish your legal techniques. You do this by oral advocacy, writing, and reading. Oral advocacy at the trial or appellate level, naturally you engage in as your practice permits. But you don't just do it, you polish it. And you polish it by several methods. You practice it in advance of the trial or appeal. You think it out. You try it on your partner, your spouse, a friend. You take postgraduate courses, yes, but you want to improve your own skills. You make friends with the clerk of court, the bailiffs, the deputy sheriffs, or marshals. You can learn an awful lot, I always found, from those people who have seen so much go on as a matter of practical experience. And I suggest that you seek out their opinions and their assistance and their criticism. After you've tried a case, especially if you've lost, ask the lawyer on the other side. Ask the trial judge what you did that might have been improved. If local custom permits, even ask the jurors what you did that could have made your case more persuasive, and try to improve on it the next time. You'll be surprised what sometimes things that you thought were perfectly convincing turned out not to be. Certain arguments or methods, mannerisms, what have you. Experience as such in a real sense means very little, because some very experienced lawyers that I see and know continue to make the same old mistakes. Experience means something only if you learn from your mistakes. And if, as happened to me, not once but several times early on, a substantial case comes along that may be beyond your abilities or capabilities, I firmly recommend that you do not hesitate to engage the assistance, if you're not working in a firm with such a person, that you engage the assistance of an older, more experienced advocate. He or she will guide you through the troubled waters, will make you look good in the eyes of your client, and will impart to you a knowledge and a know-how that is the key to self-confidence. I was fortunate enough, again, in life to have just such a person, a fellow by the name of Harold O'Brien, who was had been a basketball coach at the Rutland High School, and never went to law school, went on to become a lawyer, as you can in Vermont even to this day, by clerking in a law office. And he was the finest trial lawyer and the finest man that I ever could possibly have come into contact with. And that man just did so much for me in these early tough cases, and he gave me all of the credit even while he was teaching me, and I recommend it to you early on. The client will love it and will love you for it. So polish your skills as an advocate. but also write. Write for the law reviews. They're maybe not the Georgia Law Review, but a lot of them are starved for good material. Write for the Bar Association journals, even for case and comment. There are dozens, literally hundreds of publications. And to stand out from the crowd, part of my prescription is to write. If nobody wants to publish you, publish yourself. That's what I did when I went to Vermont. There wasn't any place to publish in Vermont. There wasn't a law school, there wasn't a law review, there wasn't a Bar Association journal, but they had an outmoded law of discovery, and I thought it needed changing, and I wrote something about it, and I mimeographed it, and I handed it out at the Bar Association. Well, I thought it was a worthwhile experience. Choose a new topic, something that interests you but that you know little about, explore it in depth and write it up. Take an old, accepted institution or principle and give it a new slant. Knock some of the barnacles off an old hull. I use that because the law of admiralty, which we have a lot of in the Second Circuit, is an old hull of law and needs the barnacles knocked off. But perhaps a more appropriate metaphor would be to say, horrible as it sounds environmentally, knock some of the moss off the old live oaks. Do not be deterred from taking a position out of fear that someone may disagree with what you say. As a district judge, I had the Court of Appeals disagree with me. As a Court of Appeals judge, I've had other judges of my court, as well as justices of the Supreme Court, only last week, disagree with me, and before, and after. Even as a law clerk on the Second Circuit, I had people disagree with me. One doesn't tell what went on in one's clerkship, but I think I can share with you this story. Bennett, I had told it to, and she insisted that I did share it with you. We had a case, a conspiracy case back in the days when I was law clerk, and all three judges had voted to reverse the conviction, but I had a theory that was the government's theory. It wasn't just mine. I thought the government was right, that a conspiracy continued after the end of the conspiracy for the purposes of concealing the conspiracy. And I was able eventually to sell my own judge on this proposition. And he was sufficiently persuaded that he got in Judge Augustus' hand across the hall and had me give this extra oral argument to him. And finally Judge Swan. And sure enough, this was a great moment in the life of a law clerk, right? I had actually persuaded the entire court to come around to a point of view, and they wrote it up, and they were all agreed. And when United States against Krulowich came down 9-0, reversing the court, I was reversing the Court of Appeals. I was long since gone from the court, but I dodged seeing Judge Chase on the street for about a year. Oh. Such is the state of things. At any rate, I know that my own analytical and writing facilities were improved by the experience, and yours will be too. Thirdly, in this first part, and I don't want to drag this out too long, but I am teachy when I get with young people. Don't forget to read. This is so lovely. It can be done. It has to be done in your spare time. I'm not talking about reading briefs, advance sheets, the daily newspapers, your daily mail. You have to do that anyway. What I'm talking about is reading outside. And I'm also not talking about Thucydides and Herodotus and Plato. You know, that was Judge Learned Hand's prescription for reading, even though you have to do that at some point. Wait, that can wait till later. I'm talking about reading the great cases and the great trials and the great arguments. The famous British trial series, the American state trials, They're gold mines of psychology and drama and rhetoric and advocacy. You should be well acquainted with the trials of Jesus, of Galileo, St. Thomas More, the bloody assizes, the witches of Salem, the trial of John Peter Zenger, the British soldiers at the Boston Massacre, whom John Adams defended. You should know the background and the history of the cases of Tom Mooney, Sacco Vanzetti, the Scottsboro Boys. You should have more than passing familiarity with the closing arguments of Clarence Darrow, the cross-examinations of Max Stoyer, and the appellate arguments and advocacy of John J. Davis. And you should even know the foibles of the Melvin Bellis and the F. Lee Baileys and the Louis Neisers of today. All of this you can do by reading. And you'll be amazed at how in a pinch sometimes what you have read somewhere along this line will help you out, will pull your irons out of a fire, a question asked on cross-examination by Sir Edward Carson in the trial of Oscar Wilde, another little way of asking a particular question, and it is an extraordinary experience that you will have, and even if you never have it, you will have enjoyed the reading. Oral advocacy, writing and reading, that's number one part. Number two, professional association and improvement. It also has three elements. First, association. Do not just join, but work in your bar associations, local, state, and national. Every local association needs work. Many of them, at least in my part of the country, are purely ceremonial. Perhaps not down here, but some of the local ones are ceremonial. Improve the courthouse. Get new chairs for the jury. Take a project. Promote a county law library. Every state bar, and Lord knows the American Bar Association, is just loaded with committees of every variety that you can think of, and there is some committee there that specializes on a subject that will be dear to your heart. If there isn't one, start an impetus for such a committee. Join, volunteer, work in the committee. I guarantee you this, that the friendships alone that you will make in bar association work will make it worth it, regardless of the other headaches or the waste of time. Just tonight, coming here quite by accident, Ben asked a fellow here in the law school to give us a ride. His name was Kirk McAlpin, and Kirk McAlpin of Savannah is a friend of long standing that I've known and admired and see from time to time here from Georgia. And this could multiply. If you do this work in the Bar Association, it multiplies the country over, and you have literally friends from the entire United States. Second, seminars. Postgraduate education is soon to become a must, I really feel, simply to maintain in good standing your license to practice around the country. But beat the standards to the punch. Go to the National Institute of Trial Advocacy or the American Trial Lawyers Association seminars to improve your trial techniques. Go to the Practicing Law Institute meetings that are held all over the country for your substantive law, or whatever seminars are put on by your bar associations or your law schools for your substantive specialties. Become the best tax or air crash or domestic relations or civil rights or whatever lawyer in your city, town, or county, and teach at the seminars or bar review, or like my good friend and again, just a lovely, lovely man who has made my stay on the Court of Appeals for the Second Circuit such a great delight and pleasure, Harold Medina. Be like Harold, to start your own bar review as he did, and you can become a millionaire while you're on your way to becoming a federal judge. Thirdly, reform. Association seminars and reform. Pick out something that needs reforming and is realistically capable of being reformed. Not a Don Quixote windmill, but whether it's the court system or the system of procedure or substantive law, think about it and propose a reform and write about it and talk about it. You can talk about it in front of laymen at the service clubs. You can write it up for guest editorials. Every state, and goodness only knows the federal government, has something in its legal system that sorely needs reforming. Outmoded or unfair practice, a method of jury selection, an impediment to swift and equal justice. Pick it out and work at it and never give up on it. And at a given point, you'll be absolutely amazed at how much unexpected assistance and help you have in bringing it about, whether it's a newspaper, an elected official, a union, some other group, but make it your reform. Well, that's what I call professional association and improvement. Bar association work, seminars, and judicial reform. Now for the third element, Dr. Oakes' prescription. Get into public service work. Public service. This too can take several forms. Indeed, some of it may come naturally if you followed my first two suggestions, polishing your legal techniques and professional association and improvement. You can be in public service and do legal work, for example, representing a state agency or the executive branch or a local or municipal body. But you treat it as a public service and a public trust, give it the highest priority and the lowest billing. You can also accept appointive or run for elective office. I hope I haven't put the lights out. I mean, that's that nuclear power company in South Carolina just shut off for a couple of weeks of probably unnecessary repairs. That's all right. You don't have to do this for more than a limited time. I like to think of the old phrase, a tithe. A tenth of your time will be sufficient for this work, but at least a tenth. The pay will be lower. The headaches will be plenty, but it will give you a necessary feeling of dedication. And I highly recommend, having done it and done it partly successfully and partly unsuccessfully, that you run for office, preferably county or statewide. In my own case, I had two. I ran for office twice from my county to the state senate, and I was quite successful. I ran for lieutenant governor, and I was unsuccessful. I was licked by a fellow who's presently the governor of Vermont, a good friend. And I ran for attorney general, and I was successful. In fact, I was the only Republican, awful word, but I was the only Republican elected on our state ticket that particular year of 1966. So automatically, I ran for governor in 68, and again I got licked by a fellow who became governor. So I had a little bit of both ways. But I do recommend that you run for office. I saw today at the moot court argument a marvelous T-shirt which happened to have been worn by a young woman. It said, a woman's place is in the House or the Senate. And I love it, and I completely agree with it. Win or lose, you will have an unforgettable experience. It will simultaneously give you a feeling of tenderness and toughness. And the combination will be invaluable throughout your professional life. Tenderness, I think, in the sense of humility and understanding of the poor, the downtrodden, the underprivileged, the disabled, the elderly, the retarded, all of the people that you meet in the course of a political campaign. But toughness in the sense of being able not only to handle defeat, the slings and arrows of outrageous fortune, so to speak, but also toughness in the sense of being able to stand the charges and the barbs of not only the opposition but the opposition press. We have a fellow up in New England, and I happened to have, purely an aside, represented his second wife in their domestic relation proceedings, but he was a publisher of a big paper in New England, and you may remember that Senator Muskie had a little bit of trouble with him, and Jimmy Carter handled him quite capably here a day or so ago, and he landed in New Hampshire and referred to the Manchester Union leader and talking something about didn't have to worry about professional responsibility here or something. I've forgotten his exact words. At any rate, you get a few of those editorials, Oakes the hypocrite or what have you, and it tends to toughen you up, and I think it's a good thing. Harry Truman's "If you can't stand the heat, stay out of the kitchen" is, I think, the very best advice, and it'll enable you to keep cool when the going is rough. Furthermore, being in politics a little bit, running for office, will also teach you, as another one of my mentors, Senator George Aiken, once told one of my law clerks on his way to becoming or going to work for the Senate Foreign Relations Committee. Senator Aiken said to Jeff Shields, he said, when you go to Washington, he said, put your illusions on the shelf. And illusions, I tried to figure out, Senator Aiken is very sort of owlish and very wise, and you have to read some meaning into his various comments. But illusions, by definition, are what you see in glass, and glass breaks easily. You will learn a lot about yourself in politics, and hopefully that Mark Twain's aphorism about fooling some of the people all of the time, and all of the people some of the time, but not all of the people all of the time, will certainly occur to you. Even if you don't get into elective politics, at least get into politics and help somebody else run, and I mean really help. So there you have it. Dr. Oakes' prescription for becoming a federal judge. 3 P's. Polish your legal skills, professional association and improvement, and public service work. The beauty of the prescription is that if you do not want to become a judge or do not become a judge, it will still help make whatever legal career you do pursue successful, and it will help make your life productive as well as enjoyable. Oh yes, I almost forgot. I did say there were 5 parts, not just 3, to the prescription. Don't worry. The last 2 will take no time at all to recount. In fact, they can be said in 7 words. Love the law and lots of luck. And that's what I wish you. Thank you.
On behalf of the Georgia Law Review and the Moot Court Board, again, I thank you for being here tonight. And I urge all members of both those institutions to detain, rudely or not, if you must, Judge Oakes for just a few minutes and take advantage of the chance to talk to this gentleman. Again, thank you. I won't add to what Dean Beard has said about the Georgia Law Review, although from my biased viewpoint, I could go on all night. I really hope that our work will speak for itself when all 5 issues have been completed. You can let me know. There are a huge number of people I want to thank and recognize tonight, and I apologize for that in a way. I know that sometimes it's a painful process, and it'll be much easier for me to run down the list very quickly. I am much too appreciative of all these people, and much too proud of them to do that. If you'll bear with me, I'm going to make some individual comments and ask some people to be recognized. First of all, I would like to recognize those Georgia professors who will appear in Volume 13 of the Georgia Law Review. And before I do that, I'll thank Professor Richard Wellman for serving as our faculty advisor, we worked out a deal at the first of the year in which we agreed that if he never saw me again, that would be an indication that things were going well. And I haven't had to bother him too many times, so I hope that is some indication that we were able to carry it off. But I appreciate the fact that he was available at all times for aid, and the year's not over yet, so that's just a warning. These professors will appear more or less chronologically in the Georgia Law Review. Professor Robert Brusack, if you would stand and wave or something if you're here, I'd really appreciate it. His article on Judge Lewis R. Morgan, A Partisan Retrospective. Professor Ellen Jordan, just sign here, it's only a formality, parole evidence in the law of commercial paper. Professor Perry Centel, The Omen of Openness in Local Government Law. Dr. Werner Chafin, The Probate and Establishment of Domestic and Foreign Wills, an Analysis of Statutory Requirements. Sandra Huzak and Frederick Huzak, A Model of the Law Communication Process, Formal and Free Law, and Part 2, Informal Law. Professor Julian McDonald, A Note in the Georgia Contracts Code. Dean J. Ralph Beard, In Their Own Image, The Reframing of the Due Process Clause by the United States Supreme Court. Radical viewpoint. That'll be at number 2. And again, Perry Centel, an article on liability of local officials, subtitled Rights for Their Wrongs. I appreciate each one of you very much, and I'd appreciate if everyone would please applaud for them collecting. I'm now ask Hugh Davenport, who is our executive editor, to assist me in the handing out of the certificates. And we'll try to move this along. I'll see if I can't have maybe 2 people moving at once at the very least. First of all, this year's managing board, I'll begin. Hugh, you can present your own certificate to yourself. Joe Lanier, who's our managing editor this year. Okay. Joan Grafstein, articles editor. Edward Krugman, articles editor. Richard Carlson, notes editor. Kata Kilgore, notes editor. Alan Willingham, notes editor. Jane Fugate, recent decisions editor. I'll give a moment for some of the bodies to clear. Wayman Johnson, recent decisions editor. Dorothy Summerall, recent decisions editor. Valerie Caproni, research editor. Wayne Thorpe, research editor. The following are all senior editors for this year. Carol Baird, Roy Harold Meeks, Jr., Reese Wilson, and Mary Catherine Zachary. You think that list was long? You ain't seen nothing yet? Staff members for this year: Bill Asbell, Steve Ashby, Doug Bennett, Bob Bennett, Dal Burton, Steve Cornelison, George Crooks, Chuck Dalziel, Rufus Dorsey, Sharon Douglas, Daisy Floyd, Tim Floyd, Sandy Folsom, Mark Forsling, dramatic pause, Sally Garr, Charlie Gherkin, Rob Goldsmith, Michael Habiff, Hank Harris, Carlton Henson, Mary Higginbotham, Cliff Johnson, Richard Lee, Kirk McAlpin, Danny McGinnis, Sarah Ellen McIntyre, Jeff Muir, Martha Mullins, Bob Nall, Don Nelms, Floyd Newton, John Sprague, Sharon Strange, Brinson Williams, John Worley, Mark Warsham. You can see I've pretty much run out the alphabet.
Anybody here hadn't been recognized?
Gee, I hope not. And of course, our Executive Secretary, Jane Davis. At this time, of these people I just called out, I would like to, I suppose, officially announce, for everyone's information, the new managing board of the Georgia Law Review. Why don't we hold our applause? I'm slow, but it gets there after a while, I realize. And then really come up with a rousing one at the end, probably be much more impressive in that way. Certain people won't be able to tell the disparity, you know. So, research editors, if you'll, I guess, continue standing. Let's do this. Research editors, Cliff Johnson and Bill Asbell. Notes editors, Rufus Dorsey, Sharon Douglas, Martha Mullins, John Worley. Recent decisions editors, Sandy Folsom, Mary Higginbotham, Danny McGinnis. Articles editors, Daisy Floyd, Charlie Gherkin. Managing editor, Hank Harris. Executive editor, Floyd Newton. And the man I envy most tonight, the editor-in-chief, Tim Floyd. A few very brief comments and I will sit down. I'd like to express thanks to the staff of the Georgia Law Review and the managing board this year, all these people I've worked with. It's a job that you get, and I think all of us got, not really knowing what to do with it, where to go with it. On my own part, I can honestly say that with very few negligible exceptions, I've enjoyed it immensely. If you can say the same thing, given the product that I'm confident we're putting out, it will have all been worth it. I thank you for all the effort, for grinning and bearing it so often. Anita, again, it's my own part. Anita once made a comment that she thought I would rather manage or edit the law review than eat. As is obvious, that was not a choice I had to make this evening. I do think it captures some of the truth of the matter. I've enjoyed it that much, and I thank you. Three other people I want to thank very quickly, and I'll be through. And this is certainly not in order of importance, because the first is Anita. I thank you for being willing to wake me up on the couch at 5 in the morning and unwrap galleys from around me and put me safely to bed. And I look forward in future years to seeing more of you and our daughter than was possible this year. And I thank you for your patience and your love. Secondly, I think it's only appropriate to mention again the name of Jane Davis, who has been, to me, a shining light throughout the year. The only person I've ever seen who could be perpetually happy. And when you come in and you're not, that of course is disgusting. But it does help. The help she's given me, I can't describe any more than just to say thank you again. The last person I want to thank, as you might have guessed, is Dean Beard. Bert has described Dean Beard as the thing that makes this run or something like that, and that pretty much captures quite a bit of it. I think there are really two questions that a dean can ask of a student leader when he comes to him. And the first question that most would ask is, how much does it cost? I thank Dean Beard for making that the second question all year long. And the first question has always been, will it help the law review, and will it help the University of Georgia School of Law? And that has been the paramount question, and I'm convinced his paramount concern. I thank him, and I thank all of you for indulging me in this.
Turnabout is fair play, because I have the pleasure of making two presentations of two guests tonight on behalf of the Georgia Law Review Managing Board and staff. I'm confident that we're the only law review in the whole country who has an editor-in-chief that's John Belushi's twin. But we've been so fortunate this year to have he's the samurai editor-in-chief. We've been so fortunate to have such capable leadership in the back office this year. And first, we want to thank Kevin for all his hard work and dedication, and for his sense of humor this year. And it's made being on managing board and being on law review a very pleasant experience. This is on behalf of the law review. And the second presentation is to Hugh Davenport, who is the executive editor this year. He too has just been wonderful to work with and has provided us with his leadership and talent. And thank you, Hugh.
My name is Mike Morris, and I've had the pleasure this year of being the number 2 man on the moot court board. And as you all know, it's hard to be number 1, no matter if you're the president of the university or the dean of the law school, president of the Tiddlywinks team, or president of the moot court board. I think you have seen tonight and have heard tonight the record of the moot court teams this year. This has been, if not the best, one of the best years in the history of the law school as far as our competitive record. And we're very proud of it. And we're proud of the person who has kind of been the glue of the moot court board. And Bert, I think you've got a present. It's not as large as the other ones. I think it will suffice. Thank you.
I certainly would expect to come after President Davison and Dean Beard, but after the president of the Tiddlywinks Club, I thought I'd be ahead of him. But there are a few presentations I would like to make in recognition of the reason that I get certain accolades like this. It's almost embarrassing to receive such words when it is the efforts of so many people that brought all this success to the moot court board and to the Georgia Law School. And in recognition of that, I would like to call these people up, let you see who they are, and let you know what they did, and then we'll, again, save it all for the end, sort of, because we're running a little behind, and I see Professor Kurtz's hands are shaking, and he's about to fall under the table. The bar, we have called, the bar is still set up, and they're not going to put it up. First of all, I would like to say that the moot court board has a tremendous debt of gratitude to its 2 faculty advisors, Mr. Paul Kurtz and Mr. Bob Brusack. I think Mr. Brusack fell into it quite by accident, and he has fought the whole time to stay alive and make us do great things. He is a former moot courter himself at the University of Georgia and did great things with it. And I'm sure that future moot court boards can look to some great leadership from both he and Mr. Kurtz, and we're really grateful for that. Okay. Again, not in necessarily order of importance or even in any order whatsoever. Okay.
Right stack.
This is the right stack. Okay. This year, the national team had a coach for the first time, and Bill DeGolian was the coach. He took a great deal of pressure off the team members in guiding them and helping with all the administrative details and listening to them, encouraging, and all this sort of stuff. So we'd like to present this to Bill DeGolian, who was coach of the national team. Patty Warren, a member of the national team, is not with us tonight. Jane Cook-Barwick is with us, and I'd like for her to receive this. Jane was a national team member, and is David Harrison here? There he is. David Harrison is also, he shaved, and I didn't recognize him. We had 2 coaches of the American Bar Association team, Miss Mary Jacqueline Wilkes and Mr. R. David Ware. Incidentally, folks, we have a much smaller office and a much smaller staff. So, the coach of the Holderness competition team this year was Mr. Neil C. Gordon. The coordinators of the Russell competition, which many of you witnessed today, were Mr. Frank L. Wilson III and Mr. J. William MacArthur. The Jessup competition, of course, is Mr. J. Griffin Doyle, who now that his job in Washington is over, is taking part in all that Washington has to offer. We didn't question him exactly what that meant, but we'll save that for him, and for Patricia Warren, who's also not here with us, who is also a member of the national team. The interstate competition coach and the guy that brought these trophies back to us again this year, we were very grateful for, was Mr. Barry P. Harris IV. The coordinators of the Talmadge competition, which you saw today, were Mr. Glenn Johnson. And I'd like to say that and I don't think any of the board will hold me for holding this one until now, Ms. Jo Lanier, also a coordinator of the Talmadge competition, was, as you've already seen, managing editor of the Law Review. While she was also coordinating the Talmadge competition, she was also putting on this banquet. She was also remaining, I can say conservatively, as one of the top 10 members of our class, and in all of that found time to get engaged to our Hal Meeks. So, we're amazed. And of course, my vice chairman and cohort in this endeavor, vice chairman of the Moot Court Board, Michael A. Morris. I'd like to now present to you Mr. Paul Kurtz, who you have seen up and down occasionally, who has a few words for us and wants to make a special presentation. He's going the long way around. You can get the whole thing, folks.
First of all, yeah, I'll clean it up, don't worry. First of all, I want to thank my colleague on the federal bench, Judge Oates, for his kind remarks. And I just want to point out that if you follow all of his advice and a little bit more, you get to be a law clerk sometime. Actually, I'm particularly glad to be up here this evening because I have 3 more pages of my introduction to Judge McCree I'd like to read. But serially, I'm really glad to be up here because I get a chance to show President Davison and Dean Beard the tie I'm wearing this evening. Plus the fact that I think Ralph and I are the only 2 people in this room without a certificate from somebody or other. We'll have to remedy that later on. But actually, I do have a very serious and enjoyable task for me. I have the privilege tonight of announcing the new honorees and the new selections for entry into the Georgia chapter of the Order of the Barristers. The Order of the Barristers is the Phi Beta Kappa, or the Order of the Coif, if you will, of the moot court area of legal education, designed to inculcate, preserve, and publicize the skills of oral advocacy. And we have several members who I'd like to have stand as I describe them and remain standing, and we can all honor them together at the end. First member of this class is somebody who was, of course, a competitor in the Russell competition in 1977. She was a finalist in the Talmadge competition last year. She was a member of the intrastate team last year that won the best team prize on behalf of the University of Georgia. She was a member of the national team this year, this academic year, in 1978-79. She graduated just this past March and is now clerking on the Supreme Court of Georgia. Colonel Jane Cook Barwick, please stand. Next honoree was a member of the intrastate team in 1978 that came back with the Best Brief Award, was also the coach of this year's intrastate team, which won Best Team and Best Brief Awards, Barry P. Harris IV. The next honoree has spent more time up here than Bert or Ralph or them put together. She was a competition finalist in the Russell competition in 1977. She was a member of the intrastate team last year that won the Best Team Award. She was coordinator of this year's Talmadge competition. She was coordinator of the Law Review Moot Court Banquet this year that we attend tonight. She was also a great help to me as an appellate practice instructor this year, one of 4 members of the third-year class who served as appellate practice instructors, Miss Freda Jo Lanier. The next honoree was a member of the American Bar Association team last year, served as vice chairman of the Moot Court Board this year, and also helped me as an appellate practice instructor, Mr. Michael Morris. The next honoree, a man who needs no introduction and therefore will get none, the chairman of this year's Moot Court Board, Burton L. Tillman, Jr. The next honoree, member of the American Bar Association team last year, coach of the American Bar Association team this year that will be competing in the national finals in August at the ABA convention. Also an appellate practice instructor this year, Ms. Mary Jacqueline Wills. And the final honoree is not here this evening. He's enjoying the fruits of his labors in Washington. J. Griffin Doyle, as you all know, coach of our Jessup Cup International team that has done so well. Also a member of last year's Jessup Cup team which finished second in the regionals. And these are our student honorees in the Order of the Barristers this year, and I take particular pride in inducting them and honoring them as members of the Order of the Barristers at a school which places such a great emphasis and is so successful at its moot court program. And I think they all deserve a particular debt of gratitude from all of us. I'm not going to stop until the next banquet, that's all. I have one more honor to bestow and another induction into the Order of the Barristers, and this is something special to me. This is a person who is a colleague of mine, a friend of mine, and I guess in some loose sense, a former student of mine. And I know that I'm getting old when I get to honor former students of mine, because I haven't been that long on this side of the podium. But the next honoree was a competitor in the Russell competition in 1974. He was the winner of the Talmadge competition in 1975. He was on the best team in the intrastate competition in 1975. And he was selected but could not compete as a member of the national team in 1975-76. This is what he did while he was in law school. And this, of course, is a basic part of why we honor him this evening. But I think the other and perhaps more primary, more important reason for which we honor this person tonight is the work that he's put in on behalf of the moot court program this year as faculty advisor. And I, of course, am speaking of Professor Robert Brusack. Thank you very much.
Thank you very much, Mr. Kurtz. We really are sincerely and very grateful to you for all that you do and involved with the Moot Court Board. Also, I don't know that I've really formally mentioned it, but we also, as Kevin did, owe a great deal of
law will continue to do what it has done for 120 years. That is to offer the best possible legal training to each new generation of lawyers as they go forward to meet the challenges of these changing times. I welcome the alumni and friends of the School of Law and the rest of you who are here today. I look forward with you to hearing our principal speaker, whom I consider to be a close personal friend and a man for whom I have great admiration. I hope that all of you will have an enjoyable visit, and thank you for being with us today.
Thank you, Dr. Davison. At this time, the Dean of our law school, J. Ralph Beard, will give the presentation of awards. Dean Beard.
It is upon such occasion as this that we realize we're engaged in a partnership for the purpose of carrying out our responsibility in preserving the American heritage of justice under our system of law. It is fitting that each of these partners, judges, practitioners, law faculty members, law students, and the community at large, assemble here this morning to participate in the inspiring tradition of the Law Day Address and the Academic Awards presentation. I would like to introduce to you some of our, in the Academic Awards presentation. Before I make the awards presentation, I would like to introduce to you some of our platform guests as well as some of our distinguished guests out in the audience. Some of these you'll hear from later, but we'll go ahead and introduce them at this point. Please withhold your applause until all have been introduced. First, our speaker this morning, Honorable Griffin B, Attorney General of the United States. Of course, you've met Fred Davison, the president of the university. You've met also Dana Miles, the president of the student bar. The past president of the student bar is Bill DeGolian, whom you'll meet in just a moment. The others I'll ask to stand as I introduce them. The distinguished mayor of the city of Athens, a graduate of the Georgia Law School, the lifelong secretary of the Law School Association, according to him, the Honorable Upshaw Bentley, mayor of Athens. Upshaw? There you are. The Attorney General of the state of Georgia and Mrs. Arthur Bolton, Attorney General Bolton. The President of the State Bar of Georgia, Charlie and Mrs. Hyde, Eloise Hyde. Dr. Virginia Trotter, Vice President for Academic Affairs at the University of Georgia. For those of you that have seen Dr. Trotter earlier this morning, academic life is really not that hazardous. She had an automobile accident. We're always pleased to welcome back to the campus a man for whom we all have great admiration and respect, the man for whom the Sibley Lecture Series was named in 1964, the honorary chairman of the board of the Trust Company of Georgia, and the man credited with saving public education in Georgia in the early 1960s, Mr. John Sibley and Mrs. Sibley. Also delighted to have with us former Governor Ernest Vander and Mrs. Vandiver. Former Governor Carl Sanders, whom you'll see a little later on. We're pleased also to have two members of the University System Board of Regents with us, Mr. Jimmy Dick Maddox and Mr. Torbert Ivey. Of course, it's always a pleasure to introduce the Associate Dean of the Law School, and a man who's taken on many burdens and contributed substantially to the success of the law school, Dean Ray Phillips. Out in the audience, we have the current chairman of our Law School Board of Visitors, Justice Bob Jordan. Bob? We also have the president of the Law School Association, Bob Struble. There he is in the back. And the president-elect, Bo Bradley. Bo? Where is Bo? Well, let's give all these people a round of applause. It's now my privilege to recognize the finest products of the law school's academic efforts, the students who are recipients of the awards for academic excellence. The first award is appropriately presented to the first honor graduate of the School of Law for the class of 1978. This is a cash award from the Jesse and Dan McDougall Memorial Fund of the University of Georgia Foundation, and it goes to Benna Ruth Solomon. Ms. Solomon completed her law studies here last June and is now law clerk to Judge James L. Oaks, U.S. Court of Appeals for the Second Circuit. Judge Oaks was the banquet speaker last evening. We're delighted to have him with us here today. Benna is not only our first honor graduate from last year, she not only has distinguished herself and being invited to clerk for Judge Oaks. She will assume the clerkship for Justice Byron White in August. Benna, if you'll come forward, I'll present you with this award. Now, the second award recognizes the student who has maintained the highest academic average on all work throughout his or her course of study at the University of Georgia School of Law. The recipient is presented a monetary award from the Isaac Meinhard Memorial Fund, which is to be used for the purchase of a set of law books. The student who has maintained the highest grade average from the beginning of law studies to the end is Benna Solomon. Benna achieved a 4+ average during her 3 years at the law school. It's only possible to achieve a 4.0 average, but hers was 4+. During her student days, she was also articles editor of the Law Review. Benna, I'm delighted to present you with this award. The first award, established as a means of recognizing scholastic achievement in a particular subject field, was the Torts Award sponsored by the class of 1933. Because there are 3 sections of the first-year torts class, there are 3 sets of grades and therefore 3 awards. The persons who have attained the highest marks in these sections are Michael Allen Brockstein, Charles Vincent Gherkin, Hugh Marshall Warsham. If they'll come forward, I'll present them with these awards. By the way, the person who originated these awards, Ham Loki, a member of that class, is with us. Ham, would you stand up? There he is, right here.
Test, testing.
The sixth, an Atlanta firm initiated a special subject area award, which has since become a law day tradition. The annual cash award is presented to the student who earned the highest grade in the bankruptcy course during the preceding academic year. Here from the Atlanta law firm of Macy and Zusman, representing that law firm is Sam Zusman, a graduate of the Georgia Law School in 1954. I'll ask Sam if he will come forward and make the presentation. The award this year goes to James Patrick Claiborne. Dean Ray Phillips is the professor for the bankruptcy. The Georgia Municipal Association has established an award which recognizes achievement in the study of law of municipal corporations. The cash award goes to the student who earned the highest grade in the municipal corporations course offered each year. Representing the Georgia Municipal Association is Norman Fletcher, president of the GMA City Attorney's Section, and Ed Sumner, general counsel of the organization. Both representatives are graduates of the Georgia Law School and are here today, and I'll ask them to come forward and make this presentation. Norman? Let's see. The recipient is Philip Hartley from Gainesville. The Georgia Society of International and Comparative Law has established an award in international law. The purpose of the award is to give recognition to the best paper in this area written at the School of Law during each year. Secondly, the goal is to increase the awareness of the students and faculty of the International Legal Studies program at this law school and the role of Professor Dean Rusk in the formation of these programs. Mr. William Felipe, a 1976 graduate of the law school who now practices in the Netherlands, provides the award. The 1979 recipient of the Dean Rusk Award in International Law is Richard Carlson. Richard? Thank you, Bill. alumni of the Black American Law Students Association are the sponsors of an annual achievement award which is given to a BALSA student member who has provided the greatest service to black law students at the University of Georgia. The 1979 recipient of the BALSA Annual Achievement Award is Emerson Henderson. Emerson? The United States Law Week Award goes to the student who made the most improvement in the third year over the second year. The award winner receives a complimentary subscription to Law Week. This year's winner is David Eldridge, who now practices in Atlanta. David? The law school is very fortunate in having a distinguished panel of 9 attorneys and judges serving on its Board of Visitors. This panel was established by the Board of Regents of the university system in 1964 to serve as an advisory committee to the school. Each board member serves a 3-year term. We would like to publicly recognize the services of 3 of our visitors whose terms ended in December. Alex Gaines, one of those members, could not be with us today, but the other 2 are present, and I would like for them at this time to come forward to receive from me, on behalf of the faculty and the student body, certificates of appreciation. They are Carl Sanders and Bob Reinhardt. I overlooked Bob when I was introducing the people on the platform. Bob not only has served the law school as a member of the Board of Visitors, but he's also served with the Law School Association, and he will be president-elect of the State Bar next year. We're delighted to have Governor Sanders and Bob with us today.
Thank you, Dana. The Student Bar Association annually presents a faculty book award, and the award is a plaque that hangs in the dean's office, and a plaque for the faculty member himself, and then also he chooses a book that the Student Bar Association then purchases for the library collection. The recipient is selected by members of the third-year class. I think to best convey what the award
Listen to what I have to say.
given for,
What we're going to do is the first guy, they're going to introduce one award, and while he's introducing the second award, we'll come down here,
of what the law is,
and Mary Beth will talk, and you just listen for me to tell you when to come down.
1979 is Professor Eric Holmes.
Just listen for me. Listen for that cue. You listen for my cue.
Annually, also, the Student Bar Association, in conjunction with the Younger Lawyers section of the State Bar,
Echo, I want you to give a legal ID and come down to us.
who is a member of the Younger Lawyers section of the
Just
State
fade this
Bar.
out. Give a legal idea and come down to us.
Thank you, Bill. I'm privileged this morning to present this year's 3rd Annual Professional Responsibility Award. This award is given by the Younger Lawyers section of the State Bar in conjunction with the Student Bar Association here at the law school. The award is given to that professor who best incorporates the teaching of professional responsibility and community service in the regular course curriculum. This year's winner, as selected by the student body, is Milner S. Ball. Professor Ball.
Waiting on you, Echo.
There's one more presentation I want to make before introducing our speaker this morning.
Echo.
During the past year, I've had the privilege of serving as the president of the Student Bar Association, something that I've enjoyed very much. It's a very time-consuming job. There are lots of little things that just come up all the time. But, you know, I've been the one who's been able to stand up at the podium.
Celebration of Law Day at the University of Georgia today has begun with a presentation of awards by Dean J. Ralph Beard, University Professor of Law. Of course, the featured speaker today will be the Honorable Griffin B. Bell, Attorney General of the United States. Law Day was established first in 1961. It was set aside by a joint resolution of Congress as a special day of celebration by the American people in appreciation of their liberties and the reaffirmation of their loyalty to the United States of America. The purpose is to foster respect for law and understanding of its essential place in the life of every citizen of the United States. There are an estimated 40,000 Law Day programs going on over the country today. A little later on today, there will be, after the speaker, there will be the Law School Association luncheon where Mr. James T. McIntyre, Jr., who is the Director of the United States Office of Management and Budget, will speak. And now the introduction of the Law Day speaker, Griffin Bell, by Mr. William DeGolian, President of the Student Bar Association.
What is even more important, what do you have? Really, probably nothing. And our speaker this morning is one of the most able men in the country, one of the most important men in the country, but also a man of great integrity. He has run the Justice Department without allowing any personal friendships with the President to interfere with that, and he's kept an independent course for the Justice Department. And I think is universally respected for the job he's done with it. It is our great privilege and honor to have with us this morning the Attorney General of the United States, Judge Griffin Bell.
Thank you very much. Dr. Davidson, Dean Beard, Governor Vandiver, Governor Sanders, Governor Arnold, justices and judges, particularly Judge Oaks, who made it possible for me to be here by ruling in my favor in a contempt of court case. Mayor Bentley, I have 2 FBI agents with me, and Mayor Bentley wants to borrow him. He thinks he's in more danger than I am. It'd be hard to say who's in the most danger, an Attorney General or a mayor, except for our own state Attorney General, Arthur Bolton, who's so universally beloved, I don't think he's in any danger. Mr. John Sibley and Barbara, our old mentor, other distinguished guests, ladies and gentlemen, it's a great pleasure to be here. I haven't had anything unusual happen to me since arriving on the campus. I spoke at Boca Raton not long ago at the American College of Trial Lawyers meeting, and apparently the hotel sends a limousine to meet certain people, and the FBI always meets me, and I was walking through the hotel the next morning, and a man stopped me, recognized my accent, said his name was G. Bell from Milwaukee. He wanted to thank me for the ride he had in the limousine the day before. Said he was being paged in the West Palm Beach airport, Mr. G. Bell, and he said, I thought it was unusual. Told my wife to come on, and we had a nice ride, and got about 20 miles down the road, and the limousine driver said, "You sure don't have a southern accent." Things like that happen to you as you get about the country in this job. I'll go directly to my remarks. Speaking here in the breeze is like running an obstacle course. This plant on the end has already fallen over once. If my speech blows away, you'll know I'm stopping right there. It's good to be with you. It's always good to be on the campus here at the university and be at the law school. It's a law day, so I'm going to address my remarks to something that I've been thinking a good deal about lately. Our concept of law may be inseparable from the concept of government. As long ago as 1835, Alexis de Tocqueville observed, quote, "Scarcely any political question arises in the United States that is not resolved sooner or later into a judicial question, close the quote. So in a sense, what I am about to say about the law can also be said about the government in general. The frustration felt by the private sector and by the average American citizen about the sprawling and seamless web of government regulation is a direct reflection of their concern over a major part of our legal system as well. More specifically, it is my sense that both government and law, as reflected in government regulation and litigation, are close to losing sight of a very basic goal in our country: fundamental fairness. Some of you may recall then Governor Carter's speech here at Law Day in 1974. In that address, he said his own view of the role of law in society was colored by the philosopher Reinhold Niebuhr, who had written that there is no way to establish or maintain justice without law, that laws are constantly changing to stabilize the conflicting demands of an ever-changing society, and that law is, in essence, the final expression of government's role and structure. In my own view, law is a guardian of our freedoms and of our most sacred institutions. I am proud to be a part of our nation's legal system, and I take it as a personal challenge, as all lawyers should, to see that the law is itself a fair and just mechanism for society. Indeed, to allow the law to be abused or even warped is to place our liberties in peril. There is an area of unfairness in the government's legal relations with the public which we must begin to face. Civil litigation of any sort with the government can cost a small or even not so small fortune today. Yet even if the private litigant prevails and has affirmatively demonstrated that the government took an indefensible position in a civil lawsuit or agency proceeding, that litigant must still bear much of the cost, including attorney's fees. That result seems unjust, and it is probably the worst feature of the so-called American rule on attorney's fees and cost. The Department of Justice, at my direction, is now examining the possibility of legislation which would cure this defect. This proposal would be based on the recent Supreme Court opinion in Christiansburg Garment Company versus EEOC, a 1978 case. Under this proposal, the government would be liable for attorney's fees if it acts in a manner that is, quote, arbitrary, frivolous, unreasonable, or groundless, close the quote. That language comes out of that opinion. The burden of proof would be on the prevailing party and be the subject of a separate motion at the conclusion of the litigation. I believe that such a proposal, if adopted, would do much to curb the growth of any unreasonable or unwarranted governmental civil action or agency proceeding, and would also restore a measure of fundamental fairness in litigation between private persons and the government. As government officials, we do our best to limit our cases to those which are proper and justifiable. But on occasion, there may be a case which slips by us, and our error should not be at the cost of those private litigants or defendants who are the subject of this abuse. The object of our attorney's fees legislative proposal would be to give some fair measure of redress to those persons, but without imposing a crippling cost to the federal treasury or chilling the vigor of federal attorneys. Again, our goal is to ensure fundamental fairness to all the parties, the government as well as private persons. Moreover, after a period of experience, it may well be just to extend this approach to unfounded criminal prosecutions. In the same vein, I call to your attention a rule of procedure often neglected, Rule 11 of the Federal Rules of Civil Procedure. That rule states in pertinent part, quote, "The signature of an attorney constitutes a certificate by him that he has read the pleading, that to the best of his knowledge, information, and belief, there is good ground to support it, and that it is not interposed for delay." Citing this rule to you, I take note first of the tremendous power exercised every day by lawyers over the affairs of their clients, whether the client is a government or a private individual or entity. The client must depend upon the lawyer to file such papers as he or she deems necessary and appropriate. My concern in this regard is that in the interest of advocacy, Rule 11 is too frequently ignored. How often does a lawyer stop to reflect on the presence or absence of good grounds for a filing? And how many motions and discovery proceedings are commenced, not in aid of truth-seeking, but merely to put off the ultimate day of reckoning? Or in another situation, how many appeals are taken by lawyers who know that there is an absence of good grounds for appeal, or that the appeal is interposed for delay? I cannot give you precise answers to these questions, but it is my impression as a lawyer, as a former federal judge, and as Attorney General, that Rule 11 is often violated by lawyers. Again, this violates the principle of fundamental fairness, fairness to the client, fairness to the opposing party, and importantly, fairness to the legal system. Abusive filings clog the courts and enhance the public misimpression that lawyers foster unnecessary litigation for their own interest. They divert judicial resources from the consideration of truly meritorious filings, and they obviously increase the cost of dispute resolution. And incidentally, I've just read the April 18, 1979 opinion by a district judge in the Southern District of New York, in which the court awarded $50,000 in attorney's fees and expenses to be taxed against a law firm and its client for bringing a baseless lawsuit for oppressive reasons. This is an unusual case, to be sure, and I read the opinion, and it was brought simply to, apparently, to get publicity. And the judge took good care of the lawyers who joined in that. It's important to note here that there is not even a Rule 11 requirement for criminal cases or appeals. It only applies to civil suits in the district courts. There is, however, the requirement in the Code of Professional Responsibility that a public prosecutor or government lawyer shall not institute or cause to be instituted criminal charges when he knows or it is obvious that the charges are not supported by a probable cause, close the quote. As stated in the applicable ethical consideration to this rule, quote, "The responsibility of a public prosecutor differs from that of a usual advocate. His duty is to seek justice, not merely to convict. One of my first meetings as Attorney General with the lawyers in the Department of Justice in the Great Hall of the department, I read to them Justice Sutherland's admonition from Berger versus the United States. Quote, "The United States is a representative, not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win the case, but that justice shall be done. As such, he is in a peculiar and very definite sense the servant of the law, the twofold aim of which is that guilt shall not escape or innocence suffer." Close the quote. This Rule 11 problem, or lack of a Rule 11, has prompted me to draft an Attorney General's policy that will bind all lawyers within the Department of Justice. I intend to hold each and every lawyer responsible for his or her pleadings and positions taken orally in court. If we determine that a lawyer has knowingly violated the Rule 11 concept, we will take appropriate action against the lawyer, and in addition, will confess error or take such other judicial disposition of the offending pleading or position as may appear proper. And we will notify every government agency whom we represent that this policy will be applied to every proposed filing or position taken in their behalf. As I've indicated, it is equally important that we approach federal criminal prosecutions with the same sense of fundamental fairness. The Attorney General's policy directive that we are drafting will also ensure that no indictments are recommended by a federal prosecutor unless the evidence presented to a grand jury would be at least likely to produce a conviction. We will not go forward absent highly unusual circumstances where we have only enough evidence to withstand a motion to dismiss the prosecution at the close of what would be the government's case at trial. This standard, which is even higher than the probable cause standard in the Code of Professional Responsibility, will govern both the decision to prosecute and the selection of specific charges to bring against a defendant. The public will then have greater confidence in the good faith of our prosecutions, and potential defendants will be spared the agony and expense of indictment and trial, where the government's case is at the outset only marginal. Through this new approach, I will be giving notice to the entire government that we will adhere to the principle of fundamental fairness in our dealings with the courts and with the public. I've often thought that the government's lawyers should set the highest standard of conduct for themselves and for the legal profession. This policy will hopefully set an example for the entire bar and will enhance credibility and confidence in our legal system. Moreover, we will be carrying out the spirit of the inscription that is carved on the rotunda of my office in Washington. Quote, "The United States wins its point whenever justice is done to its citizens in the courts." Close the quote. The Justice Department has taken the lead in developing these unusual approaches to law practice problems because it is our ethical duty to do so, and because the legal profession requires improvement. We must remember that Canon 8 of the American Bar's Code of Professional Responsibility states that every lawyer should assist in improving the legal system. Indeed, paragraph 8.1 of the canon makes this observation, quote, "By reason of education and experience, lawyers are especially qualified to recognize deficiencies in the legal system and to initiate corrective measures therein. Thus, they should participate in proposals and support legislation and programs to improve the system without regard to the general interest and desires of clients or former clients. Close the quote. Thus, nothing could be more appropriate than that the Attorney General, the chief lawyer for the people, and his assistants take a leading role in improving our legal system. In fact, President Carter created the Office for Improvements in the Administration of Justice in the Justice Department. This new office is staffed by 20 lawyers, headed by eminent scholars, and its sole task is to develop proposals for enhancing justice. This is one way in which we discharge our ethical duty under Canon 8. I'm glad to report that Professor Ron Ellington from the faculty here at the university will be joining that office in the Department of Justice on July 1. Would also add that improving the system by way of these policies and practices will meet Chief Justice Beggar's oft-cited criticisms of the trial bar. The changes I have described are actually the second set of innovations that have the specific aim of improving the quality of legal practice in the federal courts. The first was the expansion of the Attorney General's Advocacy Institute, which now trains over 600 lawyers a year in the fine art of civil and criminal trial practice. The Institute also gives dozens of advanced courses in specialized fields. Through the Institute, we are not only training the government lawyers of today, but the private lawyers of tomorrow, because many of these government lawyers will leave the government and go into the private sector. Better performance by government lawyers may tend to raise the levels of trial advocacy generally. And as some of these better trained young lawyers leave the government service, they will spread their training and experience throughout the private bar for years to come. Now, in closing, let me turn for one moment to history. The Roman Emperor Caligula posted the laws of his time in small print and in high places so as to keep the populace from knowing the law. This was an example of the worst kind of a legal system. But there is also a Roman example of the best. Centuries ago, the Roman Emperor Justinian said, quote, "Justice is an earnest and constant will to render to every man his due. The precepts of the law are these: to live honorably, to injure no other man, and to render to every man his due." Close the quote. It is my belief that the overwhelming majority of lawyers in our country abide by this injunction of Justinian. That is why we are proud to be lawyers and to be able to serve in a nation whose foundations rest on the rule of law. Thank you, and enjoyed being with you.
Thanks very much. It's important that we recognize a couple of distinguished guests that are here this morning. Former Governor Ellis Arnold and his wife are here this morning, and the stunning portrait of the governor was unveiled in the courtroom at 10 a.m. this morning. Governor Arnold. And also on the podium, Mrs. Diane Davidson, the wife of President Fred Davidson. And Mrs. Jean Beard, the wife of Dean J. Ralph Beard. Excuse me.
Thank you again, Judge Bill. That was an excellent speech. I have a few announcements here that we'd like to make before the conclusion of this ceremony. First of all, there are several people who have been instrumental in making this Law Day ceremony and this weekend possible, and at this time we'd like to express our thanks to them. First, to all the secretaries of the law school who have done a lot of work on this, in particular Joan Kelly, Marilyn Ellis, Bonnie McCartney, and Jane Davis. We'd like to thank also the Law Day chairperson from the Student Bar Association, Kay Giese, who's spent innumerable hours working on this Law Day ceremony. Two departments of the university here have really been instrumental in helping us. First of all, the physical plant, despite all the rain that we've had this week, has been able to help us out with erecting this platform and other things. And secondly, the Office of Public Relations here at the university has done a lot of good PR work for us. I'd like to express my gratitude to two individuals in the administration of the law school who I feel have done a lot of work for us on this, those being the registrar, Mr. Frank Polster, in the back, who has worked a lot on this, and secondly, the assistant to the dean, Mrs. Gwen Wood. The Athens Downtown Council of Churches has invited all of you to a community-wide Law Day observance tomorrow evening at 7:30 at the First Methodist Church here in Athens. Congressman Doug Bernard Jr. will speak on religion and the law. We'd like to ask that all the award recipients please stay after the conclusion of the ceremonies for photographs, and finally there will be, of course, the Law Day luncheon this afternoon sponsored by the by the Law School Association at 1 o'clock at the Georgia Center. The Ray Sips Locator race run by Mr. Milner Vall will take place this afternoon at the University track. Thank you very much.
Great job, Danny. Y'all do a fantastic job.